Good morning, everyone. We will just give the rest of our attendees a little bit more time, maybe another minute or so, and then we will start. Thank you. But welcome to everyone who is here. Good morning. Okay, I think in the interest of making sure that we respect the time of everyone who's arrived, good morning to everyone and welcome to another exciting event that is hosted by Novia. Are you able to hear me speak?
Yes, we can hear you.
Yes, we can hear you.
Fantastic. Good morning. Yes. Welcome to another exciting event hosted by Novia One Business School. I am Marilyn Ramplin and I'm the CEO of Novia One, and I will be your host for this session. We are really excited to present the second installment of our World Series, and this has been meticulously planned in collaboration with our esteemed partner Absa, and we'd really like to extend our heartfelt gratitude to the Absa team for offering to graciously share their expertise and profound experience with us as a team, but also with you as our community in the area of trusts and legacy planning. As a mother of two and a working professional, I often wonder about what will happen to my assets when I'm not around. And I'm sure you've thought about this too. And the question is, how can we protect what we have for the sake of our loved ones and those who may be vulnerable? And these are some of the important questions that are at the heart of our discussion today as we explore how to secure and how to manage assets for those close to us and for those who depend on our support until they can stand on their own financially. In our last session, we talked about wills, highlighting the importance of expressing your wishes and having your say even after you're gone. And so today we're going to go a little bit further by exploring trusts. And trusts not only preserve your voice, but it also ensures the diligent management and allocation of your assets in alignment with your wishes, thereby providing an enduring support for your loved ones. In today's session, we'll cover three important types of trusts: living trusts, testamentary trusts, and legal claims trusts. We'll break down each type of trust to give you a clear understanding and to simplify the complex details involved with each trust. We are privileged to be joined today by three esteemed professionals who are eminent experts in their respective fields. And each of these experts will cover a specific part of trust. They'll be sharing their knowledge and their experience to help us understand better. So please note that there will be no presentation for this, but this is more an informal delivery of the content for their respective sessions. So without further ado, please allow me to extend a warm welcome to our distinguished speakers for today. We have Wendell Wangra, who will be covering living trusts. We have Lysandri Snyman, who will cover testamentary trusts. And we have Jonathan Masakona, who will cover legal claims trusts. Their expertise will hopefully light the way for us through the complex world of trust, clarifying difficult concepts and hopefully offering practical tips for wise legacy planning. We would like to encourage you, ladies and gentlemen, to bring your questions, and we will try and answer as many of them. We will give our speakers the opportunity to each share their respective areas of expertise, and we will then take some questions to make sure that we have time to take all the questions. So please don't be shy to type your questions in the chat as we go, but we will reserve the questions until the end of the session, as some of your questions may be answered by some of the other presenters. So our first speaker is Wendell Wangra, who will be covering living trusts. Wendell is a seasoned fiduciary estates and trust practitioner. He currently serves as a legal and advisory specialist at Absa Trust. He brings over a decade of multifaceted experience in the financial sector. He provides end-to-end fiduciary advisory services, specializing in estate planning, wealth management, and both domestic and cross-border trust administration. Wendell also holds various prestigious titles and qualifications, including being a chartered banking professional. He has a BCom honors, a bachelor's degree in law, a postgraduate diploma in estate planning, and with ongoing studies in taxation, and is also preparing for his CFP board exam. So I think, ladies and gentlemen, that says that he definitely knows his stuff. And so, Wendell, I'm going to hand over to you to cover our first session on living trusts. Thank you. Good morning, Wendell.
Good morning, good morning. Goeiemorgen, moleni, dumelang, sanbonan, South Africa. Thank you for joining us on this prestigious event on trust, on the second World Series. So today we'll be talking about trust, myself and my esteemed colleagues, Lusandri and Jonathan. And on my part, I will be having a discussion around living trust. And at the onset, I will take you through the topics that will form the basis of my discussion. And these are the topics that relate to the living trust. So first off, I will start and I will kick us off with a basic introduction about what exactly is a living trust. Then I will introduce you to the parties to the living trust, after which our attention will then turn on what exactly is the structure of the specific trust, and where do these parties to the living trust actually fit within their structure. And this will place us in a position to look at the types of trust that is recognized within South African law. We'll then talk about how a trust can be beneficial to you as a founder by looking at some of the benefits of the living trust. We will then look at an extremely important aspects within South African trust law, and that is the founder and what his rights are in relation to the trust assets that he just transferred within the trust. I will then finish off with a bang by highlighting the purposes of why you would want to create actually a living trust. Now, there are several methods for the creation of trust within South African law, and that is based on whether the founder is alive or has become deceased. These, ladies and gentlemen, are called the testamentary trust, known as the trust mortis causa, and then we've got the living trust, known as the inter vivos trust. Now, the trust mortis causa, these are trusts that are formed on the death of the founder and are created within the terms of his will when the founder has become deceased. Now, the living trust, on the other hand, are formed during the lifetime of the founder, and this is the trust that will form the basis of my discussion. I will quickly speak now on the legal basis of a living trust before I delve into the detail around the workings of the trust. So the general viewpoint is that an inter vivos trust or a living trust is created by means of a contract, a sort of stipulatio alteri, which is a Latin term that actually means a contract that is entered into for the benefit of a third party. Now, who are the parties that enter into this particular agreement, and who is the third party on whose benefit this contract or this agreement is entered into? Well, it is yourself, the founder, it is the trustee, and then we have the beneficiary. And these are known as the parties to the living trust. But what exactly are the functions of these parties? So I will just talk a little bit about the functions of these parties so that we can understand. So we've got the founder, and this is the person who established the trust. It's also known as the donor because in certain circumstances he donates assets to the trust, or he's known as the settler. Then we have the trustees. Now, the trustees are responsible for the administration of the trust. The trustees must act within the law, and this is the common law, the provisions of the Trust Property Control Act, and that is the act that regulates trust as an entity itself and how the parties to the trust actually should behave within the trust. And they should also adhere to the provisions of the trustee. So I will touch a little bit later on about what is this specific trust deed and why it's so important. So the trustees control and administer the trust assets for the benefit of the beneficiaries, right? Listen to that. They control and administer the trust assets for the benefit of the beneficiaries. The trustee can also be the founder and a beneficiary at the same time. Yes, you can. As a founder, you can also be a trustee and a beneficiary at the same time. But however, very crucial and important. You as founder need to relinquish control over to the trustees, because the trustees now becomes the owners of the specific assets, and they now become the owners of the assets within their capacity as a trustee, not in their personal capacity, in their personal capacity, and the assets no longer belongs to the founder. Now we will talk about the importance of the relinquishing of control aspect a little bit later on. Then we've got the beneficiary. These are the people that benefit under the terms of the trust deed and who the trust has been established for. So you cannot just for the sake of it, because, hey, I've got a trust, establish a trust. A trust needs to be established for the benefit of a third person, and that is the beneficiary. And they derive their rights from the terms of the trust deed. Now, take note, ladies and gentlemen, there cannot be a valid trust if there is not at least one beneficiary. Now, while we're on the topic of beneficiary, I want to talk a little bit about the beneficiary, because I think as a founder, it's important for you to understand, and as a trustee as well, same can be said about beneficiaries, so that we can understand who the parties are and what actually happens when we appoint beneficiaries. So beneficiaries can be classified into income beneficiaries, and they can be classified into capital beneficiaries. Now, the income beneficiary will receive the income that the asset generates in the trust, right? The capital beneficiary will receive the asset within the trust. Now, example of this, ladies and gentlemen, is, let's say for argument's sake, we've got Ms. Zamafuze, and Zamafuze's got two sons, Vanya and Malusi, and she creates a trust and place, let's say, a fixed property for argument's sake, such as a house, into the specific trust to be leased out within the rental market. And the trust deed that she's drafted indicate that Vanya, beneficiary 1, should receive the house when he has attained the age of 30, and Malusi, beneficiary 2, should receive the rent income until the house has been distributed to Vanya. In this instance, ladies and gentlemen, we can see now that beneficiary 1, which is Vanya, is the capital beneficiary because he received the asset when he returns 30. And the beneficiary 2, which is Malusi, receives the income of the asset within the trust because he received the rent income. Now, ladies and gentlemen, in a nutshell, a living trust is an agreement that is entered into between the founder and the trustee for the benefit of the beneficiaries. So I'll pause a little bit there. All right, so now we move on to the structure of the trust. All right, so I've already indicated. So what does the structure look like? I want you to take this road with me and just try and think about what the structure could look like as I'm busy discussing, because we walk in this road together, myself and you. So we've got the founder. So the founder is the one, as we've indicated, he forms or establishes the trust and he transfers the assets to the trust. All right. Then we've got below the founder, then we've got the trustee. So what is this trust deed? A trust deed is a legal document that sets out the conditions, the terms, and the rules for the creation and the managing of the specific trust. As such, the trust deed will cover aspects such as the length of the trust and the objectives of the trust, the powers and responsibilities of the trustees. It will specify the type of assets that the trust may own and name beneficiaries and the entitlement to receive income or capital from this specific trust. Now, we see, ladies and gentlemen, this trust deed is very important and it's a legal document. So basically, ladies and gentlemen, you see when the founder created it, he had to draft the trust deed. So we see this as a Quran or a Bible or a constitution that the parties within that community, within that lifespan of that specific trust has got to abide and live by. Then we've got the trust, ladies and gentlemen. Now, this is the entity who holds the assets. Now, what type of assets can be in there? We look at, it can be a business, for business trust purposes. It can be fixed property, such as a house. It can be shares or other investments as well. Then again, we've got the trustees who manages these specific assets and control the assets for the benefits of the trustees. Then we've got the beneficiary, which can be either capital or income beneficiaries who benefits in terms of this specific trust. Now, I want to speak about the amendment of this specific legal document, since it's so important. So typically, a living trust can be amended in 3 ways, all right? Amendment meaning that you change certain things on the trust. Now, remember in the beginning, ladies and gentlemen, I mentioned that the trust is a contract that is entered into between the founder and the trustee for the benefit of the beneficiary. So that means the parties to the specific trust, all of them have got to meet the requirements for a valid contract to be to come into existence, ladies and gentlemen. So how can a trust deed, living trust deed, be amended? Well, that can be amended in three ways typically. By contractual amendment while the founder is alive. Now take note again, the valid requirements of a contract must be met and it must be legal. So we can't create a trust where we say that we are going to hire a hitman for money, because that's legal. It must be legal as well, and there must be terms within the contract, and we have to have the capacity and the consensus actually to act. An amendment also, a second way that the trust deed can also be amended is in terms of a variation clause within the trust deed. So when the trustee drafts a trust deed, he can include a variation clause. And all right, now this usually takes place when the founder has passed away, where they rely on the variation clause, or rather the amendment clause. And this is a clause that is inserted into the trust deed, right? And then the third way that we can amend a living trust is if there's no variation clause within the trust deed and the founder has subsequently passed away, then we can approach a court by way of application. Now, note in these circumstances, ladies and gentlemen, when beneficiaries have accepted a benefit under a trust, consent must be received from the beneficiaries for the amendment to take effect. Remember, I said it is an agreement entered into between founder and the beneficiary. But as soon as the beneficiary has accepted that benefits under the trust deed, it means they now a party as well. So we now have three parties. So when the amendment needs to take place, the beneficiaries must be approached for them to also give consent for the amendment of that specific contract, which is the trust deed. However, should the trustee specifically provide that the trust can be amended without the consent of the beneficiary, consequently, the amendment can take place without the trustee seeking the consent of the beneficiaries, even if the beneficiaries has now accepted the benefits under the terms of the trustee. This is so because, ladies and gentlemen, the beneficiaries have accepted the benefits within the provisions of the trust deed as is. Therefore, they will accept the benefits along with its limitation. And I call this the limitation clause within the variation when it comes to the beneficiaries, ladies and gentlemen. Now, I'll pause there for a while so that we can think about the trust deed and the parties to the trust, because what I'm going to say next is quite important for us to understand. So I'll move now to the recognition. What type of trust is recognized within South African law? And we often get this question quite often, especially when we start drafting trust deed. Now, South African law recognizes three types of trust: the ordinary trust, the divine trust, and the curatorship trust. In such a trust, so I'll start off with the ordinary trust. And in such a trust, the trust assets and liabilities of the trust are owned by the trustees in their official capacities as trustees, not in their individual capacities, ladies and gentlemen. Ordinary trust, the trustees become the owners of the trust. These assets are owned and administered by the trustees on behalf of the beneficiaries in accordance, again, with the provisions of the Quran, the Bible, or the Constitution, rather, that contract of that explain to us how the trust should be handled. This means that legal ownership vests within the trustees, but not for their personal ownership. Section 12 of the Trust Property Control Act that regulates trust as an entity provides that the trust property does not form part of the personal estate of the trustees. This means, ladies and gentlemen, that the trust property cannot form part of the estate of the trustee should he be part of divorce proceedings and for the purposes of estate duty in terms of the Estate Duty Act. Now I'll move on to the second type of trust, ladies and gentlemen, and this is the bewine trust. Now in the bewine trust, the beneficiary acquires ownership of the trust asset upon the creation of the trust. Right? So in the bewine trust, the beneficiaries now become the owner of the trust assets, and it is not necessarily from legal point of view the trustees. but their rights are limited in that the control and administration of the assets are given to the trustees. An example of such a trust is our popular legal claims trust at Absa Trust, which my colleague Jonathan will explain to you later on, where a successful road accident fund claim by a beneficiary are placed into a trust, and Absa Trust as ourselves act as an independent trustee. With this particular trust, the attorney of the beneficiary is the founder of the trust and then appoints Absa Trust as the trustee. The beneficiary acquires ownership of the funds upon creation of the trust, and Absa as a trustee administers and control these specific funds in order to preserve the funds on behalf of the beneficiary. Then we've got the curatorship trust. This type of trust is similar in structure to a divine trust. Also, the beneficiary acquires ownership of the trust, except that the assets administered in this instances for the curatorship trust is administered on behalf of a beneficiary who does not have the capacity to manage his own affairs. An example of such a trust again is our popular medical negligence claims trust, and Jonathan, my colleague, will also touch base on it. So what are some of the benefits that arises? So what are some of the benefits that arises from using a trust? Well, first of all, it provides asset protection. By placing assets into a trust, even if a beneficiary passes away or go insolvent or get divorced, the trust assets can be unaffected by such event. It provides estate freezing. So what does this mean? Essentially means that the living trust, for instance, can hold shares for argument's sake or other investments, and this can be effective in estate planning for asset protection for the purposes of any growth that takes place within the trust. Because once the shares of that specific investment is in the trust, the growth of that asset do no longer takes place within your estate. That is why it's estate freezing. It now the growth takes place within the hands of the trust. It also provides a benefit of separation from control. When there is a trust, there is separation from benefit of control. Many people cannot or do not wish to manage their own affairs, and trustees can manage and control the assets for the benefit of the specific beneficiary. Again, we've got the medical negligence claims trust that are coming up. So excited about that. Where beneficiary who has or was successful in a medical negligence claim in a court of law might not have the capacity to manage his own affairs. So Absa Trust then act as a trustee and then manage and control the funds in order to preserve it for the beneficiary. One other popular one that my colleague also spoke about, Dr. Vian van Tonner, when he spoke about taxation within the trust, is it also provides some minimization of taxes upon death. So obviously capital gains tax, you save on capital gains tax on that, and you also save on estate duty upon that. It can also be used as a business or trading trust during your lifetime. So earlier on, ladies and gentlemen, we spoke in a very important point about the relinquishing or letting go, rather, of control as the founder to the trustees. Now, that's important. Now, why is it important? So we will have a look at that. A lot of times, business trusts or family trusts are established, and the founder of the trust who owned the assets before he transferred it to the trust has now also become a trustee. Remember, ladies and gentlemen, I did mention that as a founder, you can also become a trustee. And in the case of a family trust, all too often the actual intention of the founder of the trust is to carry on controlling and owning the asset. So the real intention of the founder is then to control and enjoy the asset in the trust as though it is his, even though he will receive benefit. So this revenue, so the receiver of revenue said, no, it can't work like you can't have your bread buttered on both sides. Because the asset no longer belongs to you as the founder, but now it belongs to the trust. So when you want to draft a trust, that's something very important to take note of. Are you in a position, are you willing to let go of your trust and relinquish control to the trust to the trustees? In such a situation, if you don't relinquish control to the trustees and you have some sort of control, there's a real danger that the trust will be seen as your alter ego. Yep, ladies and gentlemen, alter ego. You will hear that within trust law for the rest of your life. And we'll see it as or rather the revenue service will then see it as you've treated the trust as your alter ego, and no legal effect will be given to recognition to the establishment of a valid trust. And the assets will then be taken into account for divorce proceedings, when in the insolvent estate, should the founder's estate be sequestrated, very scary, hey? And the deceased estate, when he becomes deceased, that means the purposes and the benefits of the trust will no longer apply to you. In the case of a business trust, all too often as well, the real intention is to create a structure where he solely controls the assets, even though it is termed as a trust, especially where the founder is seen to have direct or indirect control over the trustees or the trust assets. This will be seen as you as the founder treated the trustees as mere puppets. But how do you as a business owner or a creator of a family trust safeguard against this risk? Well, because this is a risk. It's simple, very simple. By appointing an independent trustee such as Absa Trust, we are here to advise you on such matters, who ultimately, as ourselves as Absa Trust, we are impartial in making decisions, and this is very important in terms of the trust property control and common law. Their trustees must be impartial and independent from the founder and make independent decisions. Therefore, the Chief Master's Directive 2 of 2007, ladies and gentlemen, please go read up on the Chief Master's Directive 2 of 2017, dealing with various trust matters. It refers to the implementation of the Land and Agricultural Bank case, commonly known as the Parker case. Please read up on the Parker case. It's very important. And this case emphasizes the importance of appointing an independent trustee. And us as Absa Trust, we are there to assist you on it. So why, to close off, ladies and gentlemen, I just want to speak about why would you want to be forming a trust? Why, and what would your purpose is forming a trust? What would be the reasons for? We spoke about the benefits, fair enough, and so forth. But the benefits are there, but why would it be applicable to you as a founder to be creating a trust, or for your clients, if you are dealing with clients? Well, it provides asset protection. There's an asset protection trust, rather. You can set up a trust to mitigate the effects of taxation, such as the state duty upon debt. As the assets do not form part of your estate, again, it does also not form part of your insolvent estate. Should your estate be sequestrated during insolvency proceedings, or if you get divorced, there can be no claim against any of these legal processes when the assets rather form part of a trust. One of the reasons is a family trust. We see it all too often, and this ensures generational succession planning for your children, for your grandchildren, and for any other relatives that you'd like to appoint as beneficiaries as well. Then we've got the empowerment trusts for you self-employed individuals out there. These are living trusts formed to empower staff and to give them chance of meaningful participation and sort of ownership in the business venture. An example here would be when you as an employee or an employer rather set up a trust and place certain shares within the trust and name the employees as beneficiaries of the specific trust. The trust will then be one of the shareholders of the business, and as such, the employees now will then share in the profits within the trust because the trust now has become a shareholder. Then we've got a business and trading trust. One, the purpose that you can also use, and this is to trade, and then to trade business in. Then we've got for all the nice people out there who want to create trusts for the most needy. We've got charitable trust as well that you can set up for charity. And then we've got two type of special trusts for a purpose that you probably wish to want to create the trust. We've got a special trust type A and a special trust type B. But my colleague Lusandri will touch base on the special trust type B because that forms parts of a testamentary trust rather. So a special trust type A, which I call a disability trust, is a trust created solely for the maintenance and care of a person with a mental illness as defined within the Mental Health Care Act, or any serious physical disability which precludes him or her from earning an income or managing his own affairs. An example, again, ladies and gentlemen, which will be discussed, is one of our popular legal claims trust and our medical negligence claims trust, including, ladies and gentlemen, we can see that the trust is an excellent estate planning tool, but it must be set up correctly. And it is advisable to approach someone with knowledge on trust. Very important, such as Absa Trust. We are here. Your problems are solved. Should you wish to establish a trust or have an existing trust, and you'd like to review it and to be advised accordingly. Thank you so much, Marilyn.
Thank you, Wendell. And that certainly was a very enlightening session. We have loads of questions. But what I'm going to do, as I said, I'm going to park the questions. And maybe you want to have a look at some of the questions in the chat, Wendell. But I'm going to hand over to Lusandri next. And Lusandri is going to speak specifically about testamentary trust. And Lusandri, also highly skilled legal expertise. She's a senior advisory specialist at Absa Wealth. Lusandri is a certified attorney. She earned a BCom Law and an LLB from the University of Johannesburg, along with a certificate in deceased estate practices and a postgraduate diploma in tax law. Lusandri started off at a Johannesburg law firm. She dived deep into the fiduciary world, specializing in estate planning, wills and trusts, and then enhanced the career at PwC as a fiduciary specialist, offering her services to high net worth individuals. And in 2022, Lusandri joined Absa Wealth. So Lusandri, feels like we're in absolutely good hands. I'm going to hand over to you to cover the next part of our session. Thank you.
Thank you, Marilyn, for that introduction. And ladies and gentlemen, good morning and a warm welcome to you all. As mentioned, I am Lusandri Snyman. I am the Senior Fiduciary Specialist at Absa Wealth, and I will be talking on the topic of testamentary trust this morning. So what is a testamentary trust? Now, a testamentary trust is also referred to as a wills trust. It is a type of trust that is created under the terms of a person's last will and testament, and it comes into existence upon a person's death. A testamentary trust is different from a living trust in that it is formed after a person's death and uses the contents of the last will and testament instead of a trust deed to determine the powers, the responsibilities, and beneficiaries of the trust. The terms of a testamentary trust are written into a person's last will and testament, and the will therefore forms the basis of the trust document. Now, sometimes a full trust deed is attached to a will instead of incorporating the usually shorter provisions of a testamentary trust in the body of the will, and this serves to provide additional comfort and assurance to the testator's or testatrix's wishes and ensure it will be honored. So what is the purpose of a testamentary trust? Now, a testamentary trust can be used to achieve a variety of goals, such as providing for minor children or vulnerable members of the family, such as elderly parents, beneficiaries who are not capable of managing their finances, protecting assets from creditors, or ensuring that assets are used for a specific purpose, such as education expenses of minor children or grandchildren. Now, a testamentary trust can also be used to house assets for beneficiaries who are mentally or physically disabled and who are incapable of managing their affairs. If a person has a child who suffers from a permanent mental or physical disability, or takes care of a sibling or a family member with a mental or physical disability, they can bequeath any assets intended for that person to a testamentary trust, where the nominated trustees will administer the trust assets for the benefit of that special needs person. So, for who is a testamentary trust ideal for? So, as mentioned, a testamentary trust is ideal for providing for minor children or vulnerable members of the family, beneficiaries who are not capable of managing their finances, protecting assets from creditors, or ensuring that assets are used for specific purpose, and providing for mentally or physically disabled persons. So let's dive a little deeper into this. Let's first talk on minor children below the age of 18 years. Now, this is a special type B trust, as my colleague Wendell mentioned. Now, in South Africa, children under the age of 18 years are considered minors, and they do not have the legal capacity to enter into agreements or contracts without the assistance of a legal guardian. And this impacts their ability to inherit directly. So by providing for the formation of a testamentary trust in the event of a person's death, they can proactively ensure that any assets intended for a minor child can be housed in a trust following a person's death, where they will be protected and preserved until the child is old enough to manage their own affairs. Now, in the event of a person's death, funds bequeathed to a minor child, and where no provisions for a testamentary trust was made, such bequest will be housed and administered by the Guardians Fund, which falls under the administration of the Master of the High Court, until that child reaches the age of majority. Now, the investment growth in the Guardians Fund is generally below standard, which adversely affects the capital growth of the assets. There are also annual limits on the amount of money that the child's guardian can access from the fund, which may leave that child short of funds. Consideration should also be given that should the funds held by the Guardians Fund be distributed to the child once they reach that age of majority, they might not be financially astute to manage the funds, and they can squander that money as soon as they receive it. A testamentary trust can help protect your child's inheritance from potential creditors or legal claims, ensuring that the assets are preserved for their benefit only. It allows for professional management of assets until the child reaches a certain age or achieves specific milestones, ensuring responsible financial handling. Now, a person can specify in their trust document when and how the trust assets are distributed to the child, ensuring that they have financial support when they need it most. So staggering the capital payments to them after the age of 18 years will protect them from themselves and will ensure that they will not squander that monies. The trust can provide for the child's immediate needs, such as their education, healthcare, and living expenses when a person is no longer around. The assets within the trust can continue to grow over time, providing long-term financial security for the child. And lastly, a testamentary trust usually comes to an end when the child reaches a certain age. However, this is not compulsory, and if the trust is structured correctly, the child can use this testamentary trust indefinitely for their own future estate planning. So secondly, let's talk on vulnerable members in the family, such as elderly parents or persons that are not able to manage their own financial affairs, such as your spendthrift, major children, or children that suffer from substance abuse. Now, a testamentary trust can be useful in such an instance because a person can direct how and when funds should be paid to such a vulnerable member of the family. And this will also give a person peace of mind that the family member is taken care of when they are no longer around, to do so themselves through the safeguarding and the optimum use of their inheritance. Then the protection of assets from creditors. So a testamentary trust will be an ideal vehicle for a beneficiary or an heir that is an unrehabilitated insolvent, because the ownership of the assets by a trust can protect assets from potential creditors. Such assets or bequests will not fall into a person's personal estate and will therefore also be protected from the beneficiary's creditors. Then a trust that is created for a specific purpose, such as educational purposes. Now, usually the purpose is that the money is used for tertiary studies after grade 12. However, a trust can also be created for the use of education before leaving school, so for a child's primary or secondary education. And the last topic, beneficiaries who are mentally or physically disabled and who are not capable of managing their own affairs. Now, in South African law, parties to a legal requirement must have the necessary mental capacity, and this impacts their ability to inherit directly, as the case with minor children as well. So a testamentary trust can be used to centralize and control assets on behalf of beneficiaries who are not able to do so themselves. So, ladies and gentlemen, we had a look at what is a testamentary trust, what is the purpose of a testamentary trust, and for who is a testamentary trust ideal for. So let's look at setting up a testamentary trust. Now, unlike a living trust, which is created by the trust founder through a trust deed, a testamentary trust is set up by a person's last will and testament, meaning that the will becomes the trust instrument. Now, what is particularly important to consider when setting up a testamentary trust is that if a will of a person is to be found invalid for any reason, keeping in mind that the Master of the High Court has the power to declare a will invalid, that testamentary trust will not come into existence, making it essential for those drafting the will to ensure that it is compliant in terms of the Wills Act. So a testamentary trust will consist of three parties. We'll have the testator or the testatrix, who is the person setting up the trust in their will. So they will ultimately be the founder. We have the trustees who manage the trust, and we have the beneficiaries who benefit from the trust. So generally speaking, the testator or testatrix will include a special paragraph in their will, setting out the formalities of the trust. The wording in the will must clearly indicate the intention of the testator or testatrix to create the trust, who the beneficiaries are, and which assets should be bequeathed to that trust. In addition, the will must set out the powers and duties of the trustees, the terms and conditions that apply to the trust, and nominate the trustees to manage the assets of the trust. So let's just stop at the powers of the trustees. Now, the powers of the trustees are normally derived from the trust. Important that trust instruments confer adequate powers on the trustees to ensure the proper administration of the trust. Where a particular power is omitted, valid inference may be that the founder did not intend the trustee to have that power, and accordingly, any action which a trustee is not authorized to undertake in terms of the trust will be invalid. Then the trustees. Now, the trustees have a fiduciary duty to manage the trust assets in the interest of the beneficiaries and in line with the terms and conditions set out in the will. That's ultimately the trust instrument. Now, it is essential to nominate trustees who have the knowledge and the skills to manage the assets of the trust and who the testator or testatrix believe will do so in the best interest of the beneficiaries. A professional trustee or an independent trustee, which is one of the services that Absa Trust provides, will ensure proper administration, adherence to tax and other legislation, and add objectivity. And then lastly, a very important topic to talk on is liquidity. And Dr. Wian van Tonder also talked on this topic in the first series. So while there are no charges for a testamentary trust until it commences, it is crucial to ensure that there is sufficient liquidity. So either cash or assets that can easily be transferred into cash in the trust to maintain the assets and to cover the cost involved. For example, I leave a property to the trust, so there needs to be enough liquidity for the trustees to maintain that property. So let's lastly look at what is the formal requirements for registering a testamentary trust at the Master of the High Court. Now, together with the trust instrument, the will, the following forms needs to be submitted to the Master, and this can also be found on the Master of the High Court's website. Firstly, it's an application form, a J401 form. Then a completed acceptance of trusteeship form, a J417. This should be completed by each nominated trustee, and together with certified copies of their identity documents. Then an acceptance of auditor or accountant application form, a J405, together with a certified copy of the identity document of the appointed accountant or auditor. And lastly, a beneficiary declaration form, a J450. So on receipt of all the required documents, the Master of the High Court will issue a letter of authority. So this is the same with legal claims trust and living trusts, which gives the trustees the authority to act on behalf of the trust and to administer the trust for the beneficiaries. Ladies and gentlemen, I hope this gave you more insight into testamentary trust. Thank you very much. Marilyn, over to you.
Lysandre, thank you very, very much for that presentation. I can definitely tell you that there are other parents on this call who'd like to know how to protect their children from themselves. So I think this really kind of falls into that. We have our third presentation that's coming up, but before we start, we have a very long list of questions. We may run over the 1 hour that we have allocated to the session. So if you are prepared to maybe stay a little bit longer, I'm just giving you a little bit of upfront warning. Our next session is going to cover legal claims trust by Jonathan Masakona. And I can definitely tell you in our sort of prep session for this, I learned a heck of a lot from Jonathan on this topic. Jonathan has a decade of experience in legal advisory, investments, business development, and finance at Absa. He specializes in trust and estate planning, and he provides fiduciary advisory services in estate planning, wealth management, and asset protection within the retail and relationship banking sectors. He's also a seasoned presenter on estate planning, trusts, and wills, and he holds a BCom in financial management from the University of Pretoria and a deceased estate qualification from UNISA, along with the RE1 and the RE5 certification. Jonathan, over to you on a very interesting topic. Thank you.
Thank you so much, Marilyn. I hope I'm audible. I had to adjust my...
We can definitely hear you, or at least I can.
Fantastic. Marilyn, once again, thank you. And thank you to everyone for joining in this session. As Marilyn said there, I'm Jonathan Masakona, legal fiduciary specialist for Absa. And, just to take a quick recap on, the previous sessions that my colleagues shared with you, whereby they shared very important information with regards to, estate planning, the importance of the will, and also liquidity, or putting it more simpler, the availability of real cash in an estate. Our session today obviously took an even deeper dive and focused more on the structure that one can use to ensure that you basically safeguard, you preserve, or simply protect your assets, whether it be fixed assets like property, a business interest, cash, or any other asset that you might want to protect. I think just before I even continue with my presentation, I just want us to understand that the main reason why you probably joined this session today, and also the main reason why you're probably very interested in everything that we want to say, is a simple fact that you probably have someone that you care about. You probably have a family member that you know that you need to make sure that you've made plans. You've put plans in place to make sure that they are protected. I mean, there are times when I'm sitting in, in some of our branches around the province, and, you'd find someone walking in and you'd ask a simple question. Hey, have you made a provision for, life covers? Have you done your will? Have you considered things like a trust? And the simple response that I'd get is, you know what? They will sort it out when I'm no longer there. And unfortunately, if obviously you've been attending these sessions, you'll realize that no, they will not sort it out when you're no longer there. There are, acts and procedures in place that need to be followed to make sure that you've correctly made provisions for those people that you love. So just to give a simple little explanation of where this trust thing came about, or how it started, I can imagine if you were to go on Google right now and type in history of trust, you'd come across something like this. It would read that there was a person, whether it was a father or a mother, who was leaving their home from point A to point B. Maybe they were from one country going to, seek greener pastures, or, just sort of see what's on the other side of the earth. And because they had to leave, their assets were obviously left in the care of no one, and they had to trust someone to say, look, pal, you need to look after my assets, and you need to make sure that the people who benefit from these assets are my children. So that brings us to basically the formal explanation, which obviously my colleagues have been mentioning over their past presentations they did just now, which says that a trust is formed when assets, so something of value, is given to a trustee. And as you probably know now, a trustee is someone who controls, to administer, in inverted commas, to look after, on behalf and for the benefit of the beneficiaries of the trust. So as you've learned at Absa, we offer testamentary trusts, we offer inter vivos trusts, and we offer what I'm going to be speaking about, the legal claims trusts, and we also have what we call a beneficiary fund. So how or what is the legal claims trust? So legal claims trust, it can be divided into two forms of trust that you would come across. The first being the road accident fund trust, that is the REF. Most people just refer to it as the REF trust. And then there are two ways in which that REF trust would be established. And then the first way would be through a court order. So obviously that would be involuntary. It wouldn't be by your choice. And this trust is established by a court order and is managed by Absa Trust for the benefit of a person who's injured in a road accident. So Absa would administer the funds that become available as a result of an action that occurs in terms of the Road Accident Fund, that is Act number 56 of 1996, for compensation for injuries sustained. And then you'd also have this REF trust being created voluntary. So in this instance, the trust would be established by a voluntary agreement and would be managed by Absa Trust for the benefit of a person injured in a road accident. And also in this instance, we would obviously manage these funds. So a typical example is an attorney or a guardian coming to Absa and say, okay, the court order didn't say or specify that there should be a trust created, but because we want these funds to be managed properly and with accountability, please help us as a bank or as an institution to create this trust. So that is a typical example of a voluntary REF trust. And then we move over to the medical claims trust. And then in this case, you also have this trust being created in two ways. First being with a court order. So that's an instruction from the court, meaning that that instruction, it would be involuntary, as you wouldn't have a choice in creating that. The court has said that this has to be in place. And this trust is established by a court order and is managed again by Absa Trust, if you were to select Absa Trust, obviously. And we would administer the funds that become available as a result of a successful action for damages arising from injuries sustained by the beneficiary while he or she was in the care of the doctors and nursing staff. So obviously this emanates from claims against the medical fraternity based on negligence. And then another way in which obviously this medical claims trust would be created is voluntary. So you receive these funds due to a medical negligence claim, and you decide as a guardian or as the attorney at that time, because you obviously would have the discretion, you decide, you know what, we need to establish a trust for the beneficiary or for the basically the owner of the funds. And just to give some typical examples of what we come across, at Absa. So I'm sitting at my little desk, my little cubicle. Some of us nowadays, we have very reduced spacing in the office because, most of what we do is more outside in the field than, in the office. So I'm sitting in this little cubicle. I receive a call from a lawyer in Limpopo. And then the lawyer states to me that, Jonathan, both parents of the two minor children had tragically passed away in a road accident. And the lawyer, on behalf of the guardian who was looking after those two minor children at the time, was looking for a flexible vehicle to administer the ref benefit, which was around 7 million. And then nothing in the market seemed suitable until they did an internet search and came across Absa Trust. And then one thing is that the guardian did not want the funds to be locked in. Rather, they required monthly income, and they also required occasional capital payments for the likes of school fees, etc. So she also wanted about 15% of the total to be kept aside in cash for immediate use. So obviously, at the end of the day, trust was created, and that ref payout was paid into Absa Trust for the benefit of those minor children. And then another example, a client now aged 23, had a ref trust with Absa for 8 years, and on turning 18, the trust was terminated. And then obviously he was paid out the remaining lump sum. So this is a typical example of when a trust is formed, maybe because of general damages that paid out. So a parent was maybe in an accident and they were deceased, and the money was now given to the child who was a minor, and that money was now placed into trust. And because the reason for that money being placed into trust was merely just because the child was a minor, when that child attained 18, those funds were paid out, and obviously that trust was terminated. Another example is a 34-year-old man who was severely injured in an accident and could no longer walk, and was also unable to manage his finances. As my colleagues discussed, this is also regarded as a special trust. And then after the trust was established, his house was revamped to ensure that he was obviously mobile and comfortable in his own home. So that is another example of a involuntary trust, a trust that is created by court order, which gives an instruction to say you have to place these funds in the trust because this person has been declared incapable or unable to handle their financial affairs. And then the payout for a valid ref claim. What influences a ref claim? There are a number of factors, ladies and gentlemen, that influence a ref claim. And there's the extent to which you are responsible for causing a road accident. They consider that if it's relevant in that case. The nature and severity of your injuries, and also the expected short and long-term consequences of your injuries, the medical costs involved, including likely future costs and any costs that are associated with the injuries. And also, most importantly, the loss of income or support as a direct result of that injury that you've sustained. And then when it comes to the medical negligence claim, for one to prove medical negligence, a patient and his or her attorney who's involved in the matter, they need to prove that a negligent act or omission resulted in harm. So examples of medical negligence include, failure to disclose, failure to diagnose a condition or misdiagnosis, failure to obtain informed consent to, treat a patient. So as a patient who walks into, the doctor's room or into a hospital, there must be consent given for you to be able to obviously deal with that patient. And also misreading or ignoring laboratory results, unnecessary surgery, surgical errors and wrong site surgeries, all of that can be factors that influence the claim of the medical negligence. And then victims of medical malpractice may claim compensation in the following areas where relevant in their particular case. That could be in past hospital and medical expenses, also for past loss of earnings, also for future hospital, medical, and supplementary expenses, and also future loss of earnings due to interference with earning capacity. And just as with the case of REF, also for general damages. And then if you were to come to Absa and say, Absa, please, we want you to be responsible for drafting or creating this trust for us. The simple process that we follow, you'd find that it's the same process that every institution follows in terms of registering the trust. And most of the things that I'm actually even going to discuss are things that my colleagues have touched upon already, which basically just, talks to the trust as a whole. So the first step would be a trust consultant assisting in drafting the trust documentation. My colleague Wandel mentioned the trust deed. It's exactly the same thing here in this instance. The trust documentation would be drafted, and that would be used obviously to establish the trust. And then the trust consultant is the point of contact for the beneficiary and the guardian until the trust has been registered with the Master of the High Court. Once again, as with the living trust and the testamentary trust, with the legal claims trust, it also needs to be submitted to the Master of the High Court for them to register it. And then upon receipt of the court order or the offer or settlement, we would then proceed to draft the necessary trust documentation for completion and signature. And then this documentation obviously would be provided to the instructing attorney firm for them to perusal and also for them to obviously sign. And then the next step from there would be the documentation would be presented to the Master of the High Court for perusal and obviously for the registration of the trust. And as my colleagues also mentioned, once the letters of authority have been issued, because remember, without the letter of authority, Absa at that stage does not have the powers or the mandate to be able to act on behalf of that trust that has been created. So the letter of authority, ladies and gentlemen, is literally the first thing that we look for before we can actually start operating with that trust. And then from there on, a trust administrator would be allocated to the trust, and they are then dedicated to administering the trust and assisting the beneficiary and or the guardian in that case. And then this trust administrator is dedicated to assisting the beneficiary or the guardian with the day-to-day administration of the trust. And then from there on, ladies and gentlemen, the beneficiary or the guardian will be contacted in order to explain the procedures of how the trust works, and obviously to request that they complete what we call a needs analysis form. So with the other trusts that my colleagues mentioned, you wouldn't come across this step because those are obviously trust that you would take initiative as an individual or as a client to say, I want to create this trust. But with this case where this trust is created because of funds that come from a REF payout or a medical negligence claim, then obviously we need to establish what is the need of the beneficiary on a monthly basis. Hence, there would be a process where the guardian or the beneficiary would have to go through a process of completing what we call a needs analysis to determine those needs. And then once we've done that with the client, an information letter is also provided to the beneficiary or the guardian, providing them with the necessary information concerning the trust. And once we have completed the needs analysis form, the next step from there, ladies and gentlemen, would be an investment proposal that is drafted and presented to our investment committee to confirm how much is needed to be invested in order to ensure that those assets or that capital that is in the trust grows. Because the main idea behind this is that this capital should last this person until they are no more. So in that instance, we'd have to look at the life expectancy of the child. So in a typical example, a child who receives a claim or a successful claim from REF or medical negligence and is a minor, 8, 9 years old, the funds that they will receive in comparison to someone who gets an accident at the age of 70 or 80, it's very different. Because the main thing that they would obviously look into is the life expectancy of that person who's received those funds. So you'll find, someone asking us, Jonathan, look, I received a claim, but can you explain to me why did I only receive 100,000 or 200,000 compared to my neighbor or someone who I saw on I Blew It who received, millions. As you saw, or as you heard from my previously, I did mention that there are factors that influence the amount that is paid out in a REF claim or a medical negligence claim. And obviously the life expectancy has a big influence on that. So the needs of the beneficiary at that stage are greatly taken into consideration when determining the monthly allowance. That's the needs analysis that I spoke about. And then obviously the best investment structures are chosen in order to ensure that there's maximum growth and there's also income in that trust. Then after, a debit order is set up to pay the monthly allowance over to the beneficiary and or to the guardian. So that's when obviously the trust has been created, everything is final, and now we need to pay monthly the needs of the child. And it's also the same when it comes to the testamentary trust and also when it comes to the living trust, because the founder or the reason it was created, there will be a reason to say, okay, we need to look after child X, child Y, or individual Y, individual X. And looking after them means that on a monthly basis, we need to make sure that they are taken care of, whether it's school needs, whether it's living expenses, or whatever other capital expenditure that they might experience. The main reason why you would have this thing created is because you want to have that maintaining of those people that you love. And rather, over and above that maintaining, you also want to have accountability. That's the reason why obviously you'd end up going the trust route. An occupational therapist from there on is appointed to visit the beneficiary. This is in terms, obviously, of the ref and the medical negligence claim. And then that occupational therapist would visit the beneficiary to just check how they live, their conditions, and this is actually for the rehabilitation of that beneficiary. So we as Absa Trust, we literally hold the hand of the client as soon as that trust has been established, until such time as obviously this trust is terminated for whatever reason. And then in regards to what I've just said, recommendations are then made for the purchasing of property. If properties need to be purchased, I did give in my example previously that a beneficiary had a trust with us, and we had to revamp their property, obviously, to ensure that they are able to live comfortably. And things like vehicles, if it needs to be purchased, schooling, work prospects, medical needs, furniture, whatever is needed is obviously going to be provided by that trust. And then finally, all sections of the trust are communicated, all actions of the trust are communicated to the beneficiary. And further, our dedicated trust administrators and occupational therapists assist the beneficiary, obviously, with their day-to-day needs. And then you might also have come across in the media, talks about the future of ref trusts. In 2020, the master approached the Pretoria High Court, advancing the view that the appointment of a curator bonus should be the default option in all cases where the plaintiff or the beneficiary who's receiving the funds, where that person receiving the funds from a medical negligence or ref claim is a minor, or is fully or partially incapable of managing their own affairs. So in short, the master is saying, look, if these funds are coming from ref or medical negligence, let's not do a trust, but rather let's appoint someone who obviously is appointed by the master. Let's appoint someone to look after the affairs of this person who is unable to look after their financial affairs. Then the master argued that the use of a trust should not be authorized under existing legislation, reason being that the master argued that it does not have sufficient powers to prevent the abuse of trust, and that trustees could set their own fees. The master also mentioned that the court orders were ambiguous. So at the end of the day, the court found that there was no legal basis to prevent the use of trusts in the case of ref or medical negligence claims, and that each case should be dealt with on its own merits. The courts also held that the court order creating the trust must specify the trustee fees or a method of calculating the fees. The court order should also clearly set out the powers of the trust. Once again, as my colleagues also alluded to, the powers of the trust, the Bible, the Quran, how is this trust going to be managed? So that is very important on the onset, that it has to be set out and it has to be clear and not be ambiguous. And then each trust must also have a bond of security. So this obviously would only apply to the ref and the medical negligence trust, where the trust would be required to apply for a bond of security. So this is just like a policy that is supposed to be taken by the trust institution to say that should a trustee, for some reason, hopefully this never happens, should a trustee run away with the trust funds or maybe make a bad investment decision, obviously that bond of security or that insurance policy would be used to compensate for whatever that loss will be. But as a company, you don't want to find yourself having to call upon a bond of security, because that would obviously only mean that that company is unable or was unable to deal with that trust in accordance to the powers that they were given. So as a company, that is the last thing that you would want to experience, having to have that bond of security called up. So people see a payout of a ref or medical negligence claim, they get very excited. They want to buy the latest and the fastest car. They want to remarry, unfortunately, because it's levels. But our job as Absa would be to dampen the excitement, because the hardest part is to make sure that that money is used for the purpose that it was awarded for. And that is why, or that is how we come in as an Absa Trust, and we ensure that we take those funds for the benefit of the beneficiary, and we obviously act in accordance to the instruction that is given. As I explained, if the instruction is coming from the attorney or the guardian, that would be a voluntary trust. Or in the case of a court order, we would obviously comply with whatever it is, which is the provisions provided on that court order. And yeah, that is basically my story in terms of the legal claims trust. I think my colleagues covered a lot of concepts in terms of the actual trust itself, when it comes to the trustees, as to what is a trustee, what is their job, what is their function, what is a beneficiary, what is their job, what is their function, what is the founder, how is the trust actually established. And I think my part was just merely to explain different types of trust that we also offer in Absa, but which is literally the same concept as the living trust, same concept, obviously, as the testamentary trust. Thank you so much, Marilyn, and thank you, everyone, for obviously joining in our session. Signing out.
Fantastic, Jonathan. Thank you very much for that. We have a whole bunch of questions. I see that we've actually been answering some of the questions via the chat. So what I'm going to do is, if anyone would like to put up their hand and just actually pose a question to our panelists, I will also allow that to happen. I know we're running over a little bit, but this is a big topic. This is unfortunately a topic we could have allowed a little bit more time for, but we were hoping that we could fit it into 1 hour for you. For those of you who are still here, we will send out the recording of this session. If we have your email address, you'll get a copy of the recording. So thank you very much for staying. Let's try and maybe answer a couple more questions, unless somebody would like to put their hand up and pose a question to our panelists. But one question that I do have here, there's this constant, and maybe whoever's going to pick up on this question could maybe answer two questions in one. So, I mean, how much money do you need to have in order to be able, or assets for that matter, do you need to have in order to be able to set up a trust? When does it become meaningful to leverage the structure? And what are the disadvantages of forming a trust? Who's the best to answer this one?
I think, Wendell, you can take that one.
Thank you, Wendell. We can try and keep it nice, short, sharp.
Thank you, Jonathan.
Yeah.
So there are a lot of considerations that we've got to. So we have to understand whether the trust fits into the overall estate plan of the specific client. All right. We also have to look whether are we only setting up the trust to mitigate from taxation as well? We also have to look at whether the benefit of the trust justifies the cost of administration of the trust involved in keeping the trust compliant, and whether to appoint an independent trustee to ensure that the trust is properly administered. But I think the most important question that I think that we have to ask is whether, when we want to set up a trust, is whether the founder is in a position to actually relinquish control over those specific assets. Because more often than not, you'll find that the founder is not in a position or doesn't wish to relinquish control over two of the assets to the trust beneficiaries, or rather to the trustees. To answer your question about the disadvantages of a trust, it's the trusts normally have a higher rate from an income tax and capital gains tax perspective, and there are future legislation that will actually come into play that has been proposed in relation to trust. So there is a little bit of a gray area in the futures of trust. Be it as it may, it is still wise to set up a trust should you need to, or should it form part of your proper estate plan as well. However, I saw another question about if a trust is dormant, would it be beneficial to me to keep it open? You need to understand with the changes that the South African Revenue Service has just implemented as well. You still need to provide annual financial statements. You still need to provide annual income tax returns. You still need to provide biannual provision tax returns. And being a trustee is a onerous duty. And obviously, Absa Trust finds it quite easy as well to be able to do that. So that's basically my answer to your question.
Fantastic, Jonathan. I'm sorry, Wendell. Thank you very much for that. Jonathan, I have a question that came up for you. In the event of a fatal accident or an event where or how would a parent give the instruction to establish a special trust, be it a RAF or a medical, once they are deceased?
Once they are deceased. Yeah, so remember at some point in time, there will be a guardian, whether it's a guardian who's appointed, to look after the child in terms of a court, in terms of the courts, or whether it's someone who, has been looking after the child for whatever reason. Maybe it's a parent, or it's a grandmother, or whatever the case may be. And remember, these payouts, they take quite some time for them to be processed. So by the time that payment is processed, it's 2-3 years down the line. And at that time, the guardian who's looking after the child would be able, obviously, to go to any institution, advisably Absa, and say, please assist us with this trust. Or it could be on instruction of that guardian visiting an attorney, and then the attorney would say, look, I can't assist you with setting up a trust, but you can go to that red bank and get them to do the trust for you. So yeah, so it wouldn't, I get where you're standing to say, look, the person is deceased, so how are they giving the instruction for this trust to be created? So in that instance, obviously it would be the guardian or the lawyer or attorney who's dealing with that matter who would give that instruction.
Okay, fantastic. Unfortunately, ladies and gentlemen, we have run out of time. I would love to continue this conversation, but and maybe if you really have a burning question, we will make available an email address at the end of this where you can email the speakers, and maybe they can respond to you on a one-on-one basis, or we can find a mechanism to have some of your questions answered. But really, I'd like to thank everyone for joining us for today's session. A big thank you goes to Wendell, Lysandri, and Jonathan for really invaluable insights on living trusts, testamentary trusts, and of course the legal claims trust. Your expertise has really helped us to sort of shed some light on what is actually quite a complex area of how to plan. And this world of trust estates, for some of us, can be quite overwhelming. Thank you for your practical and your wise planning tips. And I can really see how this is going to help us to ask different questions around what we think about our planning around our legacies. I also want to send out a big thank you to the people behind the scenes who make all this happen. Beryl, Verity, Katlego, Petrus, and Bianca, and the rest of the team. Thank you very much to the audience. Your participation and your questions is really what makes this session interactive and engaging. Don't forget, as I said, our journey continues. We have another event coming up on the 1st of November, covering the last of our three-part series on wills. And there's a link somewhere in the chat if you'd like to click on it. And hopefully we'll see you again. Thank you once again. Thank you to our partners at Absa and to all the attendees. Let's keep learning and planning to secure a legacy for our loved ones. Sometimes that is all we can leave. So let us do this well. So hopefully I'll see you on the 1st of November, and I wish you a great day ahead, ladies and gentlemen. Thank you very much for your participation.
Thank you. Bye-bye.
Thank you, Marilyn.
Everybody. Bye-bye.
Thanks,
Thank you.
everyone.
Bye-bye.
Bye.
Thank you. Bye.
Thank you.
Thank you. Bye-bye.
Bye-bye.